Welcome back. So as we were discussing in Mary's case, it didn't appear that guardianship would be recommended at this time. However, if appointing a guardian does become necessary, you should know what to expect from the process. In South Carolina, the probate court has exclusive original jurisdiction over all subject matter related to guardianship proceedings. The venue for guardianship proceedings is in the place where the alleged incapacitated individual resides or is present. Now, if they're admitted to an institution or there's a court order, venue is also in the county in which the court sits. You have to file a summons and petition and pay a $150 filing fee to the probate court. Now, effective January 1st, 2019, the probate court may waive this fee under certain circumstances. The petitioner must also serve both the summons and petition for the appointment of guardian upon the following people. 1. The ward or the person alleged to be incapacitated and his spouse, parents, and adult children. 2. Anyone serving as the alleged incapacitated person's guardian, conservator, or agent under a durable power of attorney, or who has his care and custody. And if no one else is notified under item 1 that I just discussed, then at least one of the closest relatives if they can be found. Who may be a guardian? Well, the general rule is any competent person or suitable institution may be appointed guardian of an incapacitated person. Now, there are priorities as to who may be appointed, and they are in the following order. The first person would be someone nominated to serve as guardian by the actual incapacitated person. Second in priority is an agent under a durable power of attorney whose authority includes powers related to that alleged incapacitated person. Next comes the spouse. After that would be any adult children, followed by the parent of the alleged incapacitated person. Number 6 would be any relative of the incapacitated person, and finally, last but not least, a person nominated by the person who is caring for the alleged incapacitated person or paying benefits to him or her. You're also going to be required to submit a criminal background check, a SLED report. This costs $25, and once it's received by the court, they're going to review those documents and know any questionable items, such as an arrest. Next, the court is going to appoint 2 medical examiners to report on the physical and mental condition of the incapacitated adult to the court. At least one of them must be a medical doctor. The second medical examiner can be a medical professional such as a nurse, social worker, or psychologist. And finally, each of those medical reports must be submitted to the court along with a doctor's affidavit regarding capacity. There's also a visitor that is required in the guardianship proceeding. A visitor meets with the alleged incapacitated adult to make sure the environment is safe and to find out more information. In South Carolina, a visitor can be a person trained in the law, nursing, or social work and appointed by the court. They can't have any personal interest in a court proceeding. Now, effective January 1st, the role of the visitor and the guardian ad litem are going to be combined. So who is a guardian ad litem? This is an individual appointed by the probate court to represent the best interests of the incapacitated adult. Effective January 1st, it can be a person trained in social work, nursing, medicine, psychology, or who has completed training to the satisfaction of the court. Now, what do? They are the eyes and ears of the court. They're authorized to investigate the case for the probate court, and they're required to submit a report to the probate court. And this appointment lasts as long as the case is being litigated until it's resolved. Every person who is allegedly incapacitated always has a right to be represented by his or her own attorney. Effective January 1st, 2019, that is going to be required 10 days after service of process if the alleged incapacitated individual hasn't submitted somebody that's going to serve as their counsel, the court is now required to appoint one. So you will always be represented moving forward. Now, a guardian has the same rights, powers, and duties over the ward that a parent has over the child. And those duties may include advocating for their best interests, determining and monitoring their residents, making sure the ward's needs are being met, right? Consenting to release confidential information, or even sometimes making end-of-life decisions. Finally, one of the most important duties that a guardian has is to encourage the independence and advocate for the ward to live in the least restrictive setting appropriate to his or her needs. You're also going to be required to file an annual report with the court regarding the guardianship status.